Well, good morning, everyone, or good afternoon, depending on where you are. It is straight up 12 o'clock noon Eastern Time, and so we're going to go ahead and get started with today's webinar on Kingdomware. And I thank you all for joining, and then those who are joining a little late, then they can pick up where we are. I will let everyone know that I am presenting this webinar from the road. I was in D.C. Yesterday for the Kingdomware oral arguments. I'm still here, got a meeting in D.C., and so I'm holed up in my hotel room, and I'm using my cell phone for audio here, so if there are any difficulties with audio as a result of that, I apologize. But I didn't want to wait. We could have waited till I got back in the office later this week to discuss what happened, but this is such a big, important case for SDVSBs and VOSBs. I wanted to go ahead and have this webinar today, give folks the opportunity to understand what happened in the court and where this case may be heading, and of course ask any questions you may want. So I've tentatively timed this at about an hour. We'll see. And of course, as you have questions as we go along, do feel free to place those in the chat window. I'll answer those if you want to send me an email offline. You've got my contact information below as well. I'm happy to answer questions that way too. But I hope you'll find this informative. And without further ado, let's get started talking about the Kingdomware case and what happened yesterday. Here's what we're looking at today. Before I get into the court, I think it's just good to have everyone on the same page involving the background of the case. And I know some of you have been following this very closely since it was first down at the GAO in 2011. Others maybe not quite as up to speed on Kingdomware, what it is, and what exactly the court's deciding. So I think it's important to understand exactly what the court is looking at so we can evaluate the arguments of the parties. So talk about the legal background of the case. Try not to get too much into the legal mumbo-jumbo there, but we do have to look at a statute to talk about that. We'll talk then about the parties' positions at the Supreme Court, and this is what exact arguments are the VA and Kingdomware making at the court, and that helps us, of course, then figure out how those arguments played out yesterday in the Supreme Court oral argument. And of course, we'll take questions at the end of the presentation. If you have them, as I mentioned, put those in the chat window. Feel free to contact me offline as well, but I welcome questions about it because that's what I'm here for, to be the eyes and ears of SDVSBs, VSBs, and other interested parties on the ground yesterday during this oral argument. And boy, it was exciting to be there. I'm glad I made the trip. So here's the very, very brief legal background of what we're looking at. This goes back to 2006. This Kingdomware case, here we are, and it's 2016, 10 years, maybe not too unusual, but by the time a statute gets all the way to the Supreme Court, it may be 10 years. But this is a statute that Congress passed in 2006. It's got this long name, Veterans Benefits Healthcare and Technology Act of 2006. I just call it the VA Act. That's kind of what the shorthand that people have adopted so that they don't have to use that whole mouthful, the VA Act, the 2006 VA Act. But that act had a lot of provisions in there for veterans. It was a comprehensive bill, but it did include this whole notion of veterans first. It required the VA to establish annual goals for contracting with SDVSBs and VOSBs, and then put in place this rule of two preference that we'll talk about, and that's really at the heart of the Kingdomware case. And that's a statutory reference right there, 38 U.S.C. 8127D. USC is the United States Code, and that's where when Congress writes a law, it finds its way into the U.S. Code. And 38 U.S.C. is the portion of the U.S. Code dealing with the Department of Veterans Affairs. So this is a statute that it finds its way into the piece of the federal legal framework dealing with the VA. It's 8127D, this tiny little piece of this comprehensive bill that spawned this entire case. So that's really what we're talking about here, this 38 U.S.C. 8127D, this rule of two preference. And I'll have that statute up on the next slide. So the Congress had a reason for doing this. I mean, they had these discretionary preferences out there. SDVOSB set-asides have been authorized since the late 90s under the Small Business Act, separate authority. Agencies were permitted, though not required, to set aside contracts for SDVOSBs. The VA was just doing a terrible job. I mean, the VA was not doing well in SDVOSB and VOSB contracting. So Congress's mindset was, well, that didn't work. The preferences that were discretionary, so we're going to push something veterans first. VA has a special obligation to SDVOSBs and VOSBs because of the unique mission of VA to support veterans. And so we really want to see, this is Congress speaking, the VA step it up when it comes to their contracting with these entities, veteran-owned companies. And so, the name that's been tossed around since the get-go is Veterans First. Veterans First. That's what this policy was known as, Veterans First. And that's the idea, that in VA contracting, veterans are going to go first, and that's what veterans believe. That was the language that was used for some period of time, even by the VA off and on, veterans first. But VA has always taken a contradictory position when it comes to the GSA schedule or the federal supply schedule, two names for the same thing. And the VA's position has been, since it started writing regulations to implement the VA Act, that it can buy off the GSA schedule without applying these preferences. That's the VA's position, and it's been a consistent position. The rationale for that position has shifted, and we'll talk about that. But the idea has remained the same, that the VA thinks it ought to be able to use the GSA schedule without applying the Rule 2. And, of course, you can see where that is going to end up with a litigation that winds its way all the way to the Supreme Court. So here's the statute. I'm not going to read this to you because you didn't come on this webinar to have a lawyer read statutes to you, for God's sakes. But here it is. If you want to just take a look at it quickly, this is the exact language that the Supreme Court is now considering, and the legal briefs, hundreds of pages, trying to tell the Supreme Court how this particular little paragraph here should be interpreted. But as you can see, what this section appears to say is that a contracting officer of the VA shall award contracts when certain conditions are met, with except as provided in subsections B and C, which I didn't quote the whole statute, but those are subsections that allow for sole source awards to SDVOSBs in certain circumstances based on the dollar value of the contract. And so what this scheme seems to say, and we'll talk about the goaling piece here at the beginning as well, for the purposes of meeting goals, but it does use the word shall. It says the VA shall award contracts to SDVOSBs and VOSBs if there's a reasonable expectation that two or more are likely to submit offers at fair prices that offer a best value to the U.S. And this is very similar language to what you see in the FAR for the small business rule too, which is also a mandatory rule, though not a statutory rule, but a FAR rule. It's the statute that is on all the way to the Supreme Court, 8127D, 38 U.S.C. 8127D. So here's GAO has sustained a protest back in 2011. The case goes all the way back to 2011, and the GAO there sustained a protest that was filed by a company called Aldevra. And Aldevra was a company that was an SDVOSB. It protested an award that was made off the GSA schedule, and the VA had bought those products without first applying the Rule 2. VA admitted that they had done that. The GAO sustained the protest, said VA did that improperly, that the VA had violated the VA Act, but the VA refused to follow that recommendation. GAO decisions are technically recommendations, and the VA refused to follow that GAO recommendation. The GAO then followed that up with 17 more protests filed by Aldevra, other companies, other SDVOSBs, held the same thing, sustained a bunch of protests. And, of course, the VA refused to follow those recommendations as well. So that takes us to the Court of Federal Claims, the U.S. Court of Federal Claims, which does have the power to insist through injunctive relief that a federal agency do something. They can actually force the VA to comply with a ruling. Unfortunately for Kingdomware, though, the Court of Federal Claims disagreed with the GAO. Or the Court of Federal Claims held it, looked at that statute, that 8127B, and said, you know, the statute talks about goals. It talks about a rule of two that's established to enable the VA to meet its goals for veteran-owned contracting. And the Court of Federal Claims said, well, you know, from what we can tell, the VA is now meeting, which it was. It's true. And so the Court of Federal Claims said, we think the statute essentially applies only when the VA isn't meeting its goals. Once the goals are met, then the VA no longer has to abide by this Rule 2. So this is the Court of Federal Claims. A different rationale than what the VA had originally advanced down in the GAO, where the VA had originally said, well, federal supply schedule purchases have long been exempt from the sort of sites under FAR Part 19, the small business set-asides. We don't see why this VA Act should be any different from those. That hadn't worked at the GAO, and so the VA kind of changed their argument, started talking about the goals section, and they got the Court of Federal Claims to buy off on that. The Court of Federal Claims disagreed with the GAO and said that the statute must be construed in light of its goal-setting provisions. It's a goal, you know, it's a statute that's designed to encourage and require the VA to meet its goals. So once it hits those goals, then it really has no effect. And so that's the court's ruling, the Court of Federal Claims, Kingdomware Technologies, and that was in 2012, November of 2012. Well, Kingdomware appealed. The next step up the chain from the Court of Federal Claims is the Federal Circuit, and that's, I should say, Federal Circuit upholds CFC decision. The Federal Circuit is an appeals court one step below the Supreme Court, and they heard it. 3 judges heard the case there. In the Court of Federal Claims, there's just 1 judge who heard the case, who decided in the VA's favor. The Court of Federal Claims heard it with a 3-judge panel, and 2 of those judges voted to uphold the lower court's decision, and they held in the majority opinion that, just like the Court of Federal Claims said, that this statute is a goal-setting statute, that the purpose of the statute is to get the VA to achieve its goals. But there was a dissenter. There's a dissenting justice, Justice Jimmy Reina here at the Court of Federal Claims, who said, well, wait a second here. You know, I think that the word shall means shall. You know, the Congress is kind of explaining why it had adopted the mandate, because it really wanted to get the VA to meet its goals. But the why doesn't mean that the mandate doesn't apply once it gets there. It's still a mandate. It's essentially just an explanation as to why Congress was doing what it was doing, not an exemption whenever the VA happens to have met its goals. So that justice, interestingly, citing a case called District of Columbia versus Heller, which is an opinion by Justice Scalia interpreting the Second Amendment, completely different case. But those of you who may know the Second Amendment know it has this introductory clause about, for a well-regulated militia that Justice Scalia said essentially explains what the Second Amendment did. It doesn't limit the scope of what followed, and that's the same rationale that this dissenting justice took. And so I see there's a question that's come in from Spencer. Good to see you on the discussion, Spencer, about what Justice Scalia's passing how that might have influenced this case. Of course, it's impossible to say, but my speculation has been that Justice Scalia would have been a likely vote in Kingdomware's favor. I think both because we talked about this lower court justice at the Federal Circuit had used Scalia's reasoning, although the VA has since changed its legal rationale. But I think more importantly because Justice Scalia had a well-known preference for applying the plain language of the statute. A well-known preference for applying the plain language of the statute. He wasn't much of one to want to go search for the subjective intent that might be hidden somewhere in the statute. And so you've got a statute here that says shall mean, shall do this, shall do that. I think there's a good chance that Justice Scalia would have said, well, that ends it. We don't need to go around hunting for what Congress might have intended here. They said what they intended, shall do it. So that's my speculation, but of course we'll never know. But it's a good question, Spencer. Thank you. So that's what the Court of Federal Claims said. They upheld that. Now, oftentimes when an appellate court rules, that's the end of the story. When this happened, when the Federal Circuit issued this ruling, extremely disappointing result, especially since one of the judges there had taken Kingdomware's position, and I said, that's probably it. The Supreme Court has complete control over its docket with a very rare exception, such as when one U.S. state sues another. Other than that, the Supreme Court gets to pick and choose which cases it takes, and it takes very, very few of them. It gets a lot of petitions every year for review and takes very, very few of them. So I understood that Kingdomware was going to try to get the Supreme Court to take its case, but said, as important as this is, don't see a lot of government contracts cases up at the court. Chances are that this decision with the Court of Federal Claims is going to stand. But to my surprise, in June of 2015, the Supreme Court did agree to take the case. That's called granting cert, is the formal term for that. The oral argument was originally supposed to be held in November of 2015. That was postponed. It was actually now, as you know, held yesterday. But here's the issue, of course, that was originally before the Supreme Court, supposedly before the Supreme Court, and it was based on the goal-setting piece. The issue was, is the VA required to provide a rule of two preference for better-known companies, even when it's meeting its goals? That was really the question that was posed by those lower court rulings, in which both the Court of Federal Claims and the Federal Circuit had said, so long as the VA is meeting its goals, it need not apply this preference. The purpose of that statute is simply to get them to meet its goals. So that was a question that everybody thought was in front of the court. Now, I filed a brief on Kingdomware's behalf, amicus brief on Kingdomware's behalf. They asked us to do that. And that brief, you can read it if you want, but it addresses that goal-setting argument. I did my best, along with my colleagues at my firm, to pick that apart, and I think we did a pretty good job of it. And other briefs were also filed. Ours obviously position advocating for small businesses and SGBSBs and VOSBs. But a number of veterans organizations, such as the American Legion, Iraq and Afghanistan vets, et cetera, also filed briefs in Kingdomware's favor and in supporting Kingdomware. Interestingly, then, after all these briefs were filed on October 1st, the VA, with the Department of Justice here, which is representing the VA at the Supreme Court, abandoned its earlier argument. Extremely unusual here now. Abandoned its argument. So you've got an argument. This is the goal-setting argument that the VA need not follow the rule of two whenever it meets. This argument had won. It had won twice. It had won at the Court of Federal Claims. It had won again at the Federal Circuit. And so you've got a party who had a winning argument in two lower courts, and when they get to the Supreme Court, they tossed it out the window. They completely abandoned it. So the government files this shocking brief on October 1st that says, you know what, about that goal-setting thing, we were wrong about that. The rule of two does apply even when we meet our goals. And they say it, 3 or 4 times in their brief in completely unambiguous language. So they've discarded a winning legal theory. Very unusual for that to happen. And so that doesn't mean that they've given up the case, though. Instead, they essentially revert to their original theory, the one that they had used back at the GAO way back in Aldebra, and add some more nuance and layers to that. But what they essentially came down to is saying, look, federal supply schedule orders aren't contracts. If you go back to 38 U.S.C. 8127D, you'll see that it uses the word contracts. The Rule of Two applies to the word contracts. And the government's argument now is these orders aren't actually contracts. They're something else. They're a subspecies. They're a way of getting deliverables under an existing contract, so we don't have to follow the Rule of Two when we issue an order. So that is the argument that the VA has now taken. A surprising argument because, again, it was not their argument that they had won on at the lower level. Question, of course, comes up, why did they make that change? And, of course, you'll never, public will probably never know exactly why, but I think the most likely reason is simply that the Department of Justice lawyers who are taking this to the Supreme Court, who know these justices and their preferences really well, took a look at that argument and thought it was going to lose. That's the most likely outcome. Probably in part because of Justice Scalia and that District of Columbia versus Heller case that I talked about. You've got a lower court justice that's quoting Scalia, and Scalia wrote the majority opinion in Heller. So you've got a framework by which at least the majority in that case could use the exact same reasoning to rule in Kingdomware's favor here. And so the government hasn't explained why they made that shift, but my guess is because they thought that argument was going to lose, despite the fact that it had won twice at the lower courts. All right, so positions of courts. All right, and Julian, I'll get to your at the end there. That's a good question. I'm going to go to the parties' positions here at the Supreme Court, and then we will continue the presentation. And Julian and others who have questions, I'll answer probably most of those at the end of the session so we don't interrupt the flow too much. And if there's something quickly that I can fit in as I'm going along, I will do that as well. So thank you. So what are the current positions? What were we arguing about yesterday? So the government's position, of course, is that the Section 8127D, this Rule of Two, was modeled on other set-aside statutes because there are other statutes. And this isn't the first time that the government has created a statute, Rule of Two, in it. There's one for the 8A program, and there's one for the SDVSB program for other agencies, the Small Business Act's Rule of Two, Hub Zone program, Woman-Owned program, et cetera. And the government says, well, all those statutes don't include FSS. You know, that FAR Part 8 is essentially an exemption from all those other sets of statutes. So why would this one be any different? And the government says by using similar language in adopting this statute, and Congress must have intended that this long-standing exception for FSS orders would apply here too. Well, Kingdomware has a pretty good rebuttal for that. They say, well, look, this Section 8127 was adopted. Look at the history of it. These other discretionary statutes existed, and the VA was not living up to its promise to veterans under those statutes. So, the entire purpose for creating this Rule of Two mandate under Section 8127 was to avoid the sort of discretion that the VA had before the statute came about. So why would it make sense for this particular statute to have that FSS exception? Kingdomware says, this is a unique statute for the VA. It's not one of those Small Business Act statutes that applies to the other agencies, and there's a specific reason in history why Congress mandated that the VA prioritize SDVOSBs and VOSBs, put them at the front of the line, while still maintaining the flexibility for other agencies to not have to do that. So I think that's a pretty good position there. Now, the government has made a lot of policy arguments in this case, and as we get into the actual oral argument in a moment, we'll talk a little bit more about that. But the government has said, and it did in its brief, that Kingdomware's interpretation is burdensome and going to harm the VA's mission. The VA is going to have to run Rule of Two market research and analysis all the time. It will reduce speed and efficiency. That's for those who think the VA is quick and efficient already, apparently. But they're trying to make an argument that, Congress couldn't have possibly intended that we have to do this all the time. I mean, what about when we just need to order this or order that? Why can't we just go to the schedule? Why would we have to do a Rule of Two analysis? It's going to harm our ability to effectively serve veterans. And really, and I'll talk about this in a moment, that was really at the heart of the VA's argument yesterday in court. The VA is saying there's going to be extra red tape if we have to do this. We don't want to have to perform market research to see if there are SDVSBs out there who could do the job, but we've got a readily available FSS contract that we could use to acquire that good or service. Well, Kingdomware says, look, that's a policy position, but it doesn't justify driving a giant loophole in this statute. It's a long-standing principle of statutory construction, and one of which Justice Scalia in particular is very fond, that when a statute is clear on its face, when it's clear, that's it. That's the end of the story. It's not the court's job to make public policy. That's Congress's job. If the statute clearly expresses Congress's will, even if the courts think Congress's will is kind of silly or it doesn't make much sense, oh well, that's what Congress willed. If it's not illegal, then so be it. Cumbersome and unwieldy and unworkable, all those things the VA claims, which, by the way, I think are completely overblown. But all those things are not illegal, and if the Congress thought, hey, this is what we want, then and the statute's clear on that point, then that's what the court should enforce. So the court shouldn't be playing policymaker. If the VA's parade of horribles actually come to pass, very unlikely in my opinion, but if it were to be the case, the VA were to try to implement this and it just was unworkable as they claim, then Congress can always come back and amend the statute to fix it. But that should be Congress's job. This is what Kingdomware is saying. That should be Congress's job. It's not up to the court to play policymaker and read into the statute exceptions that don't exist simply because the court might think that those exceptions make sense. So Kingdomware also makes a good point that, the VA is kind of overplaying its hand. They're overstating the case. That they're acting like this rule of two is the only vehicle by which they can acquire goods or services. In fact, as we noted earlier, the statute allows sole source contracting to SDVSBs and VOSBs under certain dollar thresholds, which are pretty high, several $1 million. And so if the VA is concerned about red tape, doesn't want to have to do a competition and see if 2 or more SDVSBs are out there and then do a competition, they can just do a sole source award. That's pretty quick and efficient, isn't it? So that's another point that Kingdomware makes. The government, of course, as we talked about, says that by using the term contracts, Section 8127 necessarily excludes orders. The VA tries to argue that if Congress had intended, contracts to go to orders, then the statute would have said orders, or the statute would have used broader language, such as procurements. Is what they say. Maybe Congress would use that language. Kingdomware, I think, has a very good point here. First, Kingdomware says, look, that might make sense in a vacuum, but let's take a look at the FAR. FAR 2.101 has a definition of contract, and the definition in the FAR includes orders specifically. It's not ambiguous. It says it includes an order. It's anytime the government acquires goods or services. Kingdomware also notes that the GAO and the Armed Services Board of Contract Appeals have considered and rejected this argument before. This argument's been made that a contract is not an order and vice versa, and that these administrative tribunals who have a great deal of expertise in this area have both rejected that argument. In fact, Kingdomware points out that one of the VA's own VAR regulations also refers to an order as a contract. And so the Kingdomware says, look, VA, it seems like you think these terms are essentially interchangeable, or that an order is a type of contract according to the VAR. And finally, the government argues that its position interpreting the statute is entitled to what it calls Chevron deference. And Chevron deference is a term that comes from a case in which Chevron oil company was involved many years ago, several decades ago. But basically what that case stands for is the principle that if you have a statute that's actually ambiguous, and keep in mind that Kingdomware is saying this statute is not ambiguous, but Chevron case stands for the principle that if you do have an ambiguous statute, then the court should defer to the agency's interpretation of that statute. In other words, that the agency's interpretation of an ambiguous statute that's within that agency's scope. In other words, here 38 U.S.C., the VA saying that's within our scope, that's our statute, and it's ambiguous, so we get to interpret it, and that interpretation is due deference. So the government's saying that their interpretation of the statute is entitled to deference. Kingdomware, of course, says, well, look, what exactly are we deferring to here? The VA has been shifting its position. They've just a couple months ago reversed course on why they think the FSS is an exemption. That kind of shifting rationale can't possibly be entitled to deference. In fact, it's a rationale that seems to have been developed here in the heat of litigation, simply for the purpose of litigation advantage, and not because it represents the agency's considered viewpoint as to why this should be the case. Kingdomware also points out that the VA's current position, where really the VA is really trying to compare the VA Act to the Small Business Act and those other set-asides, that it really relies in large part on the VA interpreting the Small Business Act, FAR Part 8, FAR Part 19, and none of those are within the scope of the VA's core competency. If anything, it's the SBA or maybe the GSA that should be interpreting those statutes. So Kingdomware says, court, no deference is due to the VA's position. Of course, Kingdomware also says, and this is repeated throughout their brief, it's a primary point, this statute isn't ambiguous. You never get to the deference question if the statute isn't ambiguous in the first place. And this one isn't ambiguous. Shall mean shall. All right. Argument. This oral argument took place on February 20th. This is, of course, yesterday. This was the first session, by the way, that was held without Justice Scalia. So I mentioned earlier, folks have asked me to speculate how would Justice Scalia have felt about this case. My speculation is he would have been a likely vote in Kingdomware's favor. We'll never know. But this was the first session without Justice Scalia. And so the court did begin. Chief Justice Roberts gave a tribute, about 5 minutes or so. Justice Scalia, you saw Justice Scalia's chair there, is draped in black. It'll be that way for about 30 days, and then eventually the justices will move to new seats. I was about 5 rows back, so I had a pretty good view here of everything that was going on. So somber start to the day as everyone took a moment to mourn Justice Scalia. As I've mentioned, my practical concern as someone who's advocated on Kingdomware's side is that, no matter what you think of Justice Scalia and his politics at large, and folks, have very divergent positions on that, I tend to think that in this case he was a likely vote for Kingdomware. So it's unfortunate for Kingdomware from a practical perspective that his death untimely there. So on to what happened in the hearing, and they're both good and bad things for those, I think, who are in support of Kingdomware, as I imagine many on this call are, maybe not all. First, the idea that shall means shall. This whole idea that I think Justice Scalia would have fond of, which is, look, the statute uses the word of command, shall, the word of command. What more do we need to look at? And I think at various points, both Justices Kagan and Breyer indicated to them the statute seems unambiguous. Justice Kagan at one point said, look, shall means shall, and it does, and if a contract's in order, and she's essentially pushing the government to concede that a contract is in order, and it pretty much did, then what are we all fighting for? Doesn't that answer the case, she said. So it was a pretty good statement for Kingdomware there. Justice Breyer he has a habit of having kind of long-winded questions, but at the end of one of his long-winded questions, he said, essentially, I don't see an exception for the FSS here in the state. And he, I'll talk about in a moment, did seem interested in some of the government's policy arguments and maybe thought that Congress had maybe done something silly here. But that said, at the end of the day, he seemed to say, but I'm still not seeing an exception here for the FSS. So to the same point, similar point about the order being contract, as I mentioned, Justice Kagan pressed the government on that point, their counsel, a gentleman named Zachary Tripp, and she pressed him, look, contract, isn't a contract kind of an order? Why isn't a contract an order here? And Mr. Tripp really didn't have a good he mostly conceded that a contract is an order. But what he seemed to fall back on was, well, yeah, a contract is generally an order, but an order is a special kind of contract, and here, given the longstanding history of exempting set-aside statutes from the FSS, had Congress intended to include orders in this particular statute, it would have used the term order. So not a very satisfying explanation to me from the government as to the contract order issue. In fact, and this being kind of the heart of the government's legal case, they essentially conceded the point. I mean, this is when Justice Kagan is saying, isn't that at the end of the day, doesn't that kind of answer the case on Kingdomware's side? If a contract is in order and the statute says shall, aren't we done here? And the government, of course, didn't agree with that, but they didn't, in my mind, have a very satisfactory explanation. Justice Breyer says, isn't an order kind of a contract within a contract? Again, it kind of one of his long-winded questions, but I think that's essentially right too. But that doesn't exempt it from the statute. When the statute uses contract, it doesn't exempt contracts within contracts. It just says contract. So those pieces of the argument, I think, were good for Kingdomware. policy. And this is what I said. I was really kind of surprised in this hearing, the extent to which the government really focused on policy. And maybe this is a sign that the government's not very sold on their legal case. But the government really seemed to come, Mr. Tripp, the government's attorney, really seemed to come to the table wanting to discuss policy. How this, in his view, in the VA's view, this Rule of Two is going to be cumbersome, it's going to be burdensome, it's going to harm the VA's mission. These are themes he returned to over and over in his argument, even when the questions weren't about that. The justices would ask more legal questions, and he would sort of maybe answer them a little bit and then pivot to a discussion about policy. And so he, in my view, clearly came to this oral argument with an agenda, and the agenda was to talk about policy at every point. How, justices, if you rule in Kingdomware's favor, you're going to be harming veterans, you're going to be harming the VA's mission, you're going to be forcing us to do all these cumbersome and burdensome things. I've called it on my blog, I call it kind of the government sky is falling strategy. They're, the parade of horrors, and I think that the government's case is overblown, but that's what they came with. It was in large part policy in comparisons to the other set-aside statutes, but a lot of policy from the government yesterday. I think that Mr. Tripp probably overplayed this a bit. Justices, I think a couple of justices were probably getting a little frustrated with him when he wasn't answering their direct questions, and instead was pivoting back to the policy argument. At one point, one of the justices, I think it was Justice Sotomayor, kind of interrupted Mr. Tripp and said, well, you haven't answered my question, and then I think others could have done that too, because he was pivoting so much to this policy stuff. That said, it doesn't mean that these arguments he was making were not having any sway with the justices. It did seem to me that several of the justices did seem somewhat concerned with the policy here. And, Justice Breyer, again, long-winded, but he was skeptical that Congress would have adopted a preference that leads to 100% potential set-aside. Again, is there ever going to be 100% of VA contracts set aside for STVSBs? Of course not. The government's had a rule of two for small businesses for decades, and they can barely scrape past 23%. But these justices don't know that, and so they're looking at the statute saying, "Jesus, isn't this going to end up with 100% contracts to veterans at the exclusion of everybody else?" Justice Breyer says he's surprised that Congress would adopt such a statute. Chief Justice Roberts, says he wonders whether ruling in Kingdomware's favor will lead to additional litigation. He means bid protests there. One of the arguments the government makes is if you rule in Kingdomware's favor, then every time we decide that the Rule of Two isn't satisfied, someone's going to protest us saying that there actually were two STVSBs, and we're going to get into all these conflicts about whether those companies are capable and whether they can perform at the at fair market prices, and it's just going to be a wash of bid protest litigation. Again, I think that's a silly concern. The Rule of Two, again, the small business, under the far as small business procedures are used or not used all the time. And yeah, a handful of those cases are protested, but most of them are not. Usually the agency's decisions are made without any protest at all. I don't see any reason why this would be different, but the government is jumping up and down saying this is going to lead to a bunch of bid protests. Again, my opinion, a bit of a sky is falling sort of argument. Now, one of the things that I noticed in there, and I know as someone who practices law in this field, exclusively in this field, the federal government contract, is that some of the justices, probably all of them at least mentally, are struggling a little bit with this. These justices, keep in mind, they're asked to be experts on everything. Everything from unreasonable searches and seizures to capital punishment, complex IT issues, patents, trademark, you name it, every single aspect of law, many of which of them are very complex, and they rarely, if ever, hear government contracts cases. In fact, I'm not sure if there's ever been another pure bid protest case that made it all the way to the Supreme Court. And so it was evident from some of the questioning that not all the justices really fully understood how government contracting works and the kind of complexities of this specific question. So, for example, one or two of the justices seemed confused about whether this Rule 2 applies to STVOSBs and VOSBs or actual veterans. There's a discussion about how many veterans are there out there, and does this give them contracts without really an understanding that the statute is for verified STVOSBs and VOSBs only. That's what it applies to. Justice Sotomayor at one point asked, if ruling in Kingdomware's favor would essentially mean an end to the federal supply schedule system, just kind of a silly proposition on its face, but for someone who doesn't know this stuff, maybe not. And it sounded like she thought the government was kind of making that argument almost, and that, I'm not sure that they have, but if they did, that's not even remotely true. This federal supply schedules will continue on. GSA schedules will continue on regardless of how this case comes out. At other points, I think the justices were struggling with, vet biz. I think it was clear that none of them had ever actually been up on the vet biz system, didn't really understand what was on there, what kind of information would be used, market research. I think the government keeps talking about, how burdensome it's going to be to do market research, and Kingdomware has always said, well, it's pretty easy. Just consult your own vet biz database, plug in the right NAICS code, and see what it spits out. And the justices, I think, need to do spend a little bit of time on vet biz, try one or two of these searches and NAICS codes. I think that was a new concept to some of the justices. So you can see this in some of the questions. It's not the most comfortable legal area for these justices. So here's my concern. I get it. I get it that these are justices that are very smart, able, capable people, and they have smart, able, capable staff, but this is a new field for them. And I remember, my very first government contracts class in law school back many years ago when I walked in there, and it was like trying to learn a foreign language on the fly. This is all, for those of us on this call, it's the language we've learned and mastered over the years. But think about when you first entered the field and being asked now, as these justices are, to be dropped in without much understanding of government contracts generally and answer a complex case like this. It requires you to understand the FSS and Rule 2 and the history of small business set-asides. I get it. It's not easy. That said, my concern here is that if the justices aren't comfortable with the subject matter, they may find the VA's, what I call the sky is falling policy arguments more compelling, because how do they know? In fact, Justice Kennedy at one point basically said that in the hearing. He said something to the effect of, since we're not government contractors, we're not experts in the field, how can we evaluate whether these horrible things you claim are going to happen are actually going to happen? And there was no real answer to that. And so that's my concern here, is that if the justices really understand the overall system, I think they'd be a little more reassured that all these things that the government is claiming are going to be so burdensome aren't really that bad. And, as Kingdomware's counsel, Mr. Saunders, at one point said, look, if the VA just invested half the effort it has spent fighting, the implementation of this to implement it effectively and get some good internal policies, that would probably answer the mail right there. Because, of course, they can still do sole sources to STVOSBs and VOSBs. There could be many cases where the Rule of 2 is not satisfied and they can just order off the schedule from somebody else. Their market research and Rule of 2 determination are still going to be granted significant deference at the GAO and other bid protest forums, which will probably mean in most cases they won't get challenged because it's just a subjective judgment call that won't get overturned. There are checks in there for micro purchases and urgent compelling needs. There's all sorts of reasons why this shouldn't be all that burdensome. And of course, the market research itself could be, needs to be tailored to the particular acquisition, but could be as simple as just pulling up the VetBiz database and plug it in a NAICS code or two, which shouldn't take that long. And so, I think that the government's really overstating the case in terms of the burdens that it thinks this will cause. But I come at that from a perspective of kind of understanding the universe of what available options are out there for the VA, and the justices don't come at it from that perspective. So, and one thing to point out on that front as well is that Mr. Saunders, Kingdomware's counsel, who I thought, by the way, did an excellent job in his in his presentation, very professional throughout, and handled some tough questions, thought feet up there. But he had an especially effective closing, because the way it works at the Supreme Court is, Kingdomware as the appellant goes first, the government then replies, the Kingdomware, they go second, then Kingdomware, they got 4 minutes to respond, to have the last word. And Mr. Saunders did a real good job in his entire presentation, but especially on that last 4-minute response. And one of the things that he said, and he, in addition to saying, hey, the government, essentially implying the government's overstating the case, one of the things he pointed out is, look, we've got a lot of veterans organizations like the American Legion, et cetera, who've all filed briefs on Kingdomware's behalf in this case. And these are organizations who, of course, work with SDVOSBs and VOSBs, but they also serve the entire community of veterans, those who have nothing to do with SDVOSBs and VOSBs, who aren't business owners, who are retirees, who were employees somewhere else. And if all these organizations really thought that the VA's mission was going to be compromised by ruling Kingdomware's favor, don't think for a minute that these organizations would have signed on to support Kingdomware in this case. And so the fact that all these organizations have lined up behind Kingdomware gives you a good sense that they all believe, even though their mission, just like the VA's, their mission is to serve veterans, that they all believe that these arguments, the policy arguments the judges are the VA is making is overblown as well. So where does the case go here? And this is an interesting question. Justice Ginsburg, when Mr. Tripp, VA's counsel, took the podium for the first time, Justice Ginsburg, and he spoke for maybe 3 or 4 seconds, and Justice Ginsburg interrupted him and said, before you do anything else, can you please explain why the government switched its position? Why are we, what happened to the goal-setting argument? Why are we hearing a new argument for the first time? And Mr. Tripp didn't have a good answer for that. As I mentioned, I think the honest answer is because the VA, the government, thought that their previously winning position was going to lose at the court and decided to chuck it out the window. And, of course, he can't really admit that to the judge. So didn't have a very good answer for that. But Justice Ginsburg kind of followed that up by saying, look, my concern here is that we here at the Supreme Court are the first court to actually evaluate this argument. Ordinarily, the Supreme Court is looking at the decision made by a lower court and deciding whether that lower court's decision was right or wrong. But it's the same arguments that were made at the lower court and the Supreme Court. Here, the lower court ruled on this whole goal-setting rationale, which both sides now agree was wrong. And so the Supreme Court's the first one, maybe the sort of the GAO back in Aldebra, but it's certainly the first court to have addressed this argument about whether contracts are orders and the effect of the other set-aside statutes. So Justice Ginsburg suggests, I don't really like that. I like to be able to review a lower court's record and suggest the possibility of actually sending the case back down the chain for either the Federal Circuit or the Court of Federal Claims or both to evaluate this argument about contracts being orders. And then 1 or 2 of the other justices seem interested in this possibility too. So, I think everyone who's been following this case since 2011 would like a definitive answer, but now this possibility has to be raised based on that discussion that it could get sent back to lower courts. I'm not saying I think that's necessarily going to happen. Now the issue has been raised. All right, so the Supreme Court should issue a decision by the end of its term in June. That decision could go one of several ways. We talked about number 3, which is remanding into the lower courts. Of course, the justices could also rule in favor of the VA. They could rule in favor of Kingdomware, which is, of course, the option I hope they choose. There could also be a 4-4 tie, because as you know, with Justice Scalia's passing, we now only have 8 justices, and that raises, of course, the real possibility of a potential tie. If there is a tie, the Supreme Court has 2 options. It could hold the case over for a rehearing. In other words, tell Mr. Saunders and Mr. Tripp to come on back whenever a 9th justice is in there. The politics indicate it could be a while before a 9th justice is in there, so it could delay the case for some time, and then everybody would come back, and they'd essentially be arguing just to one justice, so they'd all hear the case, but everybody else would have already made up their mind, and so you'd be the arguments would be directed at this new justice. Alternatively, the court could allow the Federal Circuit's ruling to stand. In fact, usually when there's a tie, that's what happens. The lower court's ruling stands, although it's not deemed precedential. In other words, the Supreme Court could still take another appeal on that issue. Usually though those ties rise because one of the justices recuses himself or herself for some reason. Justice Kagan, for example, served in the Obama administration before she joined the court, and she's recused herself sometimes from cases in which she participated when she was with the administration. And so those sorts of ties, usually if that happens, the lower court's ruling is affirmed. In this case, I think it would be downright absurd, to do that. Given that both sides now agree that the whole entire rationale for that reason ruling about the goal setting was wrong. You've got the VA and Kingdomware both saying that. So to have a decision stand that everybody seems to agree is wrong doesn't make sense to me, but that's a possibility too. So I'm going to go ahead and answer the questions that have come in off the chat box. If there's any other questions that anyone has, please feel free to make them at this time. Those who do want to jump off and go grab some lunch or something like that, I certainly understand that and won't take it personally. And so for those of you who want to do that, thank you very much for joining me. And as I mentioned, please feel free to reach out to me offline as well if you want more information about me or our firm. That's where you can reach me as Koprince at koprince.com, email. Please do visit our blog as well, smallgovcon.com. That's where we post several times a week. I've got a post up there yesterday on the Kingdomware case. I post several times a week on government contract issues. Try to write them in plain English so that everybody can understand what's going on. And finally, you'll see the copy of Small Business Guide to Government Contracts. It's a book available on Amazon and such. $22-23, something like that. Don't worry, the publisher gets about 99% of the proceeds. But I have heard from a lot of small businesses that book has been helpful to them in wading through some of this, some of the weeds of the FAR and SBA regulations and so. All right, so I'm going to take a minute to read questions, and then I will answer them as we come along here. All right, Julian asks if the VA agrees that the appeals court made the correct decision but erred in their reasoning, could the court reverse the Court of Appeals decision based on that concession and send the new question, the definition of contracts, back down to be adjudicated? And yeah, I think that's correct, Julian. That kind of goes to Justice Ginsburg's. It seems that everybody concedes that the Court of the Federal Circuit's ruling was wrong. It doesn't mean that those justices down there don't still believe in it, but the government itself has abandoned that position. So I think it is possible that the Supreme Court would say, look, we're not comfortable being the court of first resort on this question of whether a contract is in order. The justices seem not at all sure what that means anyway. We'd like the Federal Circuit to weigh in on it. We'd like the Court of Federal Claims to weigh in on it. So that's a possibility that would happen. I asked how will this change how the VA will do business moving forward? Will there be immediate changes or over a long term? And that's a good question. It depends how the decision turns out, because what we had, of course, yesterday was the oral argument, and the court hasn't issued its decision. And so if the decision comes out and it's a win for the VA, then really nothing changes. The VA is right now treating the federal supply schedule like it's an exemption from the Rule of Two. They've been doing that for the better part of 10 years now. And so if the VA wins here, then it's just business as usual. Only the veterans community is in the position of having to go to Congress and get that statute changed if we want orders to be included in the Rule of Two. If, on the other hand, the VA were to lose the case, there wouldn't, at least legally speaking, be a basis to delay implementation. I mean, the VA would be told that their interpretation of the statute is wrong. They better start interpreting it right. They better start doing these Rule of Two competitions. Whether in practice there would be essentially some sort of grace period allowed for the VA to develop some internal policies or something like that, I'm not sure. But as a legal matter, there wouldn't be a legal grace period for the VA to start following the law that they should have been following since 2006. Patrick asks, is the original basis of the protest a product or service? If the product, might the case be affected by the GAO ruling last week in Manus Medical. The original basis of this protest, as I understand it, was product. I don't think that the Rule of 2 depends too much on the product or service, so long as the Rule of 2 applies. So Patrick does raise an interesting question with regard to this GAO case came out last week called Manus Medical, and there's a blog available on smallgovtown.com that one of my colleagues wrote. If you want to read about that case, and maybe Patrick, maybe that's where you read about it too. But in the Manus case was a question about the Rule of 2 for folks who supplied products. And the question for the GAO in that case was, does the Rule of 2 apply when you have two SDVOSB distributors, or do you have to have two SDVOSBs with different small business manufacturers under the non-manufacturer rule? Because keep in mind that in order to be an SDVOSB, you also have to be a small business. And so when you're selling products to the government, being a small business means that you either have to manufacture the products yourself, or you have to comply with the SBA's non-manufacturer rule. And the SBA's non-manufacturer rule, in turn, provides, and for those who I saw in Pittsburgh at the VA conference, there's a whole presentation on the non-manufacturer rule, but I'll distill some of that into 30 seconds here. But the non-manufacturer rule requires, most importantly, that the end manufacturer, if you're a distributor, that your end manufacturer either is a U.S. domestic small business or that the SBA has waived that requirement. So in other words, ordinarily, an SDVOSB cannot provide the products of a large business under an SDVOSB set aside. You don't have to provide the products of another SDVOSB, but the manufacturer has to be a small business unless the SBA has waived that requirement by determining that there are no domestic small businesses that manufacture those products. And so in Manus Medical, the GAO held that the Rule of 2 didn't apply when essentially there's only one small business manufacturer out there. There weren't multiple manufacturers, even though there might be multiple SDVOSB distributors. So the Rule of 2 didn't apply when there weren't multiple manufacturers. And so that's I don't know whether they got that one right or wrong. It seems like one that's ripe for court litigation as well. But it's certainly the sort of case that will affect how the Rule of 2 is applied in product cases moving forward, unless the court reaches a contrary result. And I think in this case, in the context of the FSS, it's going to make it more likely that even if Kingdomware wins, if Manus Medical remains the law, that there are going to be plenty of cases where the GAO or where the VA is able to buy off the schedule legally, because they'll have found the Rule 2 doesn't apply because there are two small business end manufacturers out there. So very, very interesting case. And Patrick, I'm happy to talk with you about that at great length online. Michael, you asked about outdated specifications on bids. That is off topic, but please reach out to me online. I'm happy to have a further discussion with you on that. Julian asked why, can I elaborate on Mr. Tripp's how the VA doesn't look for SDVs within the FSS structure? And that's a good question. Mr. And several of the justices were interested in this, by the way. Those who I think understood kind of the structure and SDVOSBs and realized that SDVOSBs can hold FSS contracts, and that it's possible to do both. That you can both comply with the Rule of 2 and use the FSS simply by restricting offers on the schedule to SDVOSBs. And in fact, there's a GAO case called Crosstown Courier in which GAO held that it was perfectly fine for the VA to conduct a competition that was SDVOSB set aside but restricted to holders of a certain schedule, so long as there were two or more. In other words, the Rule of 2 doesn't have to be an open market. Everybody out there gets to bid, so long as you can restrict it in other ways, so long as you've still got two or more SDVOSBs. And so there was some interest among that from the justices, as in kind of, can't you use these tools in conjunction? And they can. That's something that I pointed out in my amicus brief to the court, saying that the VA can go ahead of the schedule and apply the Rule 2 to a schedule buy. I pointed out Crosstown Courier to them in my brief, And several justices were interested in that. Mr. Tripp's response really is that that whole setup is discretionary, and that being forced to do it is burdensome. I didn't find it all that persuasive, but I'm biased. But I think he's going back to the whole mindset that when every other agency does a set aside under a FSS schedule, and keep in mind FSS schedule set aside has only been allowed since 2010, 2011, something like that, fairly new authority under the Small Business Jobs Act of 2010. And his point was, look, just the fact that we would have to be the only agency that would have to do a mandatory set aside under the schedule is burdensome to us as opposed to other agencies. And for everybody else, it shouldn't be the same way for us. Isn't that what Congress intended in the Small Business Jobs Act of 2010? So that's pretty much his response to that point. But I think it's a good point that you raised, Julian, in that they don't have to be separate universes, that the VA is allowed to do FSS buys and limit the competition to SDVSBs, and GAO at least has held that complies with the VA Act. Vera Hudgens, you ask how can I get a copy of the presentation? We'd be absolutely happy to send you a copy of the presentation. You can email me directly at the email address you see there. We're happy to send anyone who likes a copy of the slides. We're also recording this, so if you want to hear my lovely voiceover, you don't just have to look at the slides alone. So please, anyone who'd like it, send us a copy of the slides or send us an email, and we'll send you a link or a copy of this presentation. And I see, Jen, you noticed that everyone's going to get one. So thank you, Jen. I'm moving down the line. So, Audie, Audie, you're asking the key question. What do you expect will happen given my experience? Boy, Audie, I wish I had walked out of that court knowing what would happen. I really did, because there are a lot of cases of the Supreme Court hears where you can go in there and it's pretty clear from the tone and tenor of the questions that the judges are leaning one way or another. Certain justices are leaning one way or the other. This really wasn't one of those cases. I think both the Justices asked tough questions of both sides. I think, I'm biased. I think Kingdomware's counsel did the better job and had the better end of the legal argument. I do think the justices, for better or worse, had some concerns about some of the policy issues that the VA has raised. So I really think this could go either way at this point. I wish I had a more definitive prediction. I do think Justice Scalia's vote could be missed here. And I do think there's a very real possibility that the justices kick it back down. And I think that kind of goes to the question that follows. And it sounds like from you again, Audie, in terms of, do they have enough experience to really understand this? And I wonder if, and look, I'm not intending to insult the Supreme Court in any way here. I mean, I do government contract law at 40, 50, 60 hours a week, every week. And these justices are asked to be experts on everything. No matter how smart and how talented they are, they can't possibly do that. But I do think that they not only struggled a little bit with the subject matter material, but it seemed to me that at least some of them understood that they were struggling a little bit with it. They understood that this was not, that they still had some more to go here in terms of fully understanding this. And so I do wonder if that might lead them to toward Justice Ginsburg's solution, which is to send it back down to the lower court. Or not solution, but her suggestion that she would be open to sending it back down to the lower courts. Not that would make the Supreme Court more experts in government contracting law, but that it would give them, it would essentially make the lower court, which does have that expertise, the Federal Circuit or the Court of Federal Claims, put together a strong record on this issue of the contracts versus orders that the Supreme Court could evaluate instead of being first in line here, the argument in what is a complex, nuanced field. And so I think that that's a real possibility. Again, my sense, I don't know if I could point to anything in the transcript, but my sense from being there is that some of those justices knew that they're struggling a little bit with this. And they're human beings, and they know where their core competencies are. And I think most of them realize this ain't it at this point. Again, not trying to demean them or diminish them in any way. They're a very bright, articulate group of people. And that's all we've got, I think, for questions right now. If there's nothing else, let's see. I'll add one more question, Adi. What will be the impact if this goes against us? Well, as I said, I mean, as far as practical impact of it, nothing, because the VA is currently doing what they, what Kingdomware is fighting against. The VA is currently avoiding the Rule 2 and using the FSS to purchase all manner of supplies and services and doing the end around on STVSBs. And so that's the fact on the ground right now. And if in Kingdomware's view, that means the VA is violating the law every single day. In the VA's view, then they've properly interpreted the law, so they're going to keep doing it until a court tells them not to. And keep in mind that no court's told them not to. In fact, the Court of Federal Claims, the Federal Circuit, gave them the thumbs up and said keep on doing it. So in practical terms, it means nothing on a day-to-day basis. But what it does mean is that the battle is over. Kingdomware and Aldevra and others have been pushing this fight for a while, trying to keep that, on the horizon, this idea that, at some point the VA will be forced to come to heel and will be forced to start applying the Rule 2 as I think most veterans believe it was intended, that you really do put veterans first. And not just veterans first with a giant asterisk after it saying, except when we use the FSS, then veterans can be last or nowhere. That's not what I believe Congress intended, and I don't think that's what most veterans believe Congress intended. So, the implication is that the Supreme Court comes down and says, you know what, contract's not in order, Congress couldn't have intended all these crazy, awful policy things to happen, rules in the VA's favor, then there is no more legal option here. There are no protests, there are no appeals, there's no court action that can work. Supreme Court's word is final unless Congress changes the law. And so what that means is that the veteran community would have to shift into full-on and sustained and very driven lobbying to get Congress to just add essentially the word orders to Section 8127D, and keeping in mind that, while the, veterans community has lots of powerful organizations that can take this fight, that the VA, of course, is in itself powerful and it's going to be pushing back with everything they've got on Congress saying, don't make us do this, don't make us do it, don't make us do it. But that's where the fight would head. It would head to Congress if it continues at all. Julian, you ask, will the court take into consideration the brief that was filed by members of Congress? And it's a good point that Julian raises here. There were a number of briefs that were filed in Kingdomware's favor, myself, of course, among them, several veterans organizations. There's also a brief filed by 40 or so members of Congress, also in Kingdomware's support. And I hope that Congress takes that, or that the Supreme Court takes that into effect, especially because one of the signatories on that brief is now Senator John Boozman of Arkansas, who was the primary of this bill when he was in the House of Representatives way back in 2006. And so here you've got the guy who, wrote the saying, I agree with Kingdomware. This is what I intended. And so if there's really a question about did Congress intend this or did Congress intend that, you've got 40 members of Congress, including the bill's author, saying this is what we intended. You've got no members of Congress who have signed a brief on the other side saying they intended something else. And so I hope that gets taken into consideration. It may not make its way into a decision, but if you've got the, what you think is potentially an ambiguous statute, and you've got the author telling you what he meant, for a lot of people that's going to be pretty persuasive, and I hope that that's the case here too. I'm always asking about putting in place a platform for veterans to be heard, if we have to go the political route. And yeah, I mean, there'll be time to talk about that. But yeah, we're going to need to, if it had to go the political route, we would need to rally the support of SUSBs, VOSBs, the great organizations that submitted briefs here. I was in a meeting yesterday with lots of these folks, representatives, pretty much the folks you see on the amicus briefs that were submitted to the court. their attorneys, the representatives of these organizations, and so we'd want to gather a group of those folks, and of course just all the FDUSBs and VUSBs who are out there, and undertake a lobbying effort. So I don't know what that would look like or who would ultimately take the lead, but it's certainly something that I would want to be involved in, and we'd want to gather the support of everybody we can, advocates and veterans alike. I hope it won't be necessary. I hope that the Supreme Court comes out and rules 8-0 in favor of Kingdomware in June, and I can write a blog post on SmallGovCon that starts with the word victory, but we'll see. But it's a good question, Audie, and I'm glad you're ready to jump in and do what's needed to be done here, and I know others are as well. Thanks for that. I appreciate it. And thank you to everyone. I know we've still got 36 of you who stuck around even overtime for these questions. So I really do appreciate it. I'm going to log off in just a minute here and end the presentation to lunch myself. But I really do appreciate everyone who took the time to attend this webinar today. This is a really important case. Hasn't been picked up on much by the national media because I think the issues are kind of complex and nuanced to those who aren't in the government contracting field. But to SDVUSBs and VUSBs, and those who settle the VA, those who want to settle the VA, those who simply believe the VA ought to fulfill its mission and put veterans first, this case is tremendously important. So thank you for all for joining. Touch me offline, and Jen Catloth of my office will be forwarding the presentation to everyone who attended as well. You don't get it, let us know, and we'll make sure you do. So thank you again, everyone. Really appreciate it, and please don't hesitate to be in touch. Bye-bye.